Well, hello there once again, and welcome to our Facebook, YouTube live session. My name is Lior Samfiru. A lot of you know me. They call me the employment lawyer, and well, they call me that because that's what I do. I'm an employment lawyer, and I solve workplace issues. And why am I here? Well, I could be talking to you about many things, but I'm here talking to you today again about employment law. We do this session every week. I log in here. I talk to you about employment law. I talk to you about workplace rights. I tell you what you need to know if you are facing a workplace problem. I tell you what you need to know if you're dealing with something, if there's issues that are concerning to you, if you're getting an ultimatum or a threat from your boss, if you lost your job, maybe you're worried about losing your job, maybe you've been off work for many months and you want to know how long that can last. This is the time. This is the only place of its kind where you can come, ask your questions, get the answers, and walk away with some helpful information in your pocket. So that's why I'm here for. And again, my name is Lior Samfiru. Now, you can also reach me. By the way, goes without saying, this is a live session. Post your questions. Write them. I see questions coming in. I'm going to get to them in about 30 seconds. But ask your questions. This is live. I'm here, and I want to answer your questions now, today. But to reach me off social media, easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca is my firm's website. You can get my contact information, my entire team's contact information, and you can read a lot more about your rights, about employment law at employmentlawyer.ca. First place you go to, you see that on the screen right now, that address, employmentlawyer.ca. Great resource. But today, right now, I'm live, so let's get to it. Let's answer some questions. Don't be bashful. I know you have issues. You wouldn't be here otherwise. If you're here watching, ask questions as well. First question off Facebook from Janice. Thank you, Janice, and welcome. I was told yesterday that they need my office and I can work from home on a regular basis, which I'm okay with. This was done verbally. Do I need to do anything since my work conditions have been changed? Well, if this is a change that you're happy with, then I have no problem with that. Now, the one thing I want to know, and I think you would want to know, is the intention that this be permanent? Or is this the intention that it's temporary? So I think you want to get some confirmation. Even if it's verbal, you can confirm that in writing after, because you don't want to be all set up there and, you know, maybe, well, now I can move somewhere else because I'm working from home. I don't have to travel into the office. And then 3 months later, boss says, well, now we want you to come back. So you need to have an understanding as to whether or not this is permanent or for how long, so that you can plan accordingly. But if you're okay with working from home, I have no issue with that. That's a good thing for you. So you can proceed. And again, the good way to do this, for Janice and for anyone, if you get something verbally, just send an email back to the person confirming what was agreed to so that there's no questions or misunderstandings. That works really, really well. But I'd want you to get some more information about the timelines, Janice. Any questions, any issues, reach out to me. Again, you can do that through employmentlawyer.ca. Kate Carey says, I was touched on last week as I had tried to send it to you, but a different lawyer said, yes, I have a case. Not sure what you mean. Carey, we have 37 lawyers by last count at the firm. Each one of them is phenomenal, one of the best in the province, in the country, frankly. So if you're dealing with any lawyer in my office, you're dealing with one of the top employment lawyers in this country. You're in great hands, nothing to worry about. Right now, again, ask your questions, everyone. Post them. A lot of people watching, as always. So let's answer those questions. Let's solve those workplace problems. Again, those joining us, I'm the employment lawyer. Lior Samfiru is my name. And I'm here to answer those questions. Great questions. Next question. Carrie has a follow-up. My husband was injured on the job 16 years ago and has a physical disability as a result. He was hired back 6 years ago as a health and safety rep. He was laid off when COVID hit. He works for a moving company. The boss has admitted he won't bring him back because he is disabled and can't do as much as others. What are his rights? Well, first of all, he has a right to severance. That's the easy aspect of it. And if he has a disability, then it's going to make it harder for him to find another job. He's owed even more severance than usual. So depending on your husband's age and his income level, he could be looking at even 10 months, even 12 months of pay, okay? Potentially as much as 12 months pay. But it's beyond that. If he's not going to be brought back because of his disability, that's a human rights violation. They can't do that. They can't discriminate against him or refuse to bring him back because he has a disability. In fact, they have to accommodate him. So that's illegal. So right off the bat, I have major concerns about that. So potentially, they may have to pay him additional damages for discrimination, for human rights violations. So severance, that's easy, but potentially human rights. Kerry, I think you've said you've already been in touch with one of my lawyers on my team. If you haven't or he hasn't, let's do that. Let's do that immediately today so we can help him get what he's owed. All right, great question. Thank you for that. Post yours as well, guys. You see how easy it is? A few seconds, you get your answer, you know what to do. Again, this is the employment law session here, so please answer your or ask your questions. Next question comes to us from Michelle. I don't want to work from home anymore. I have told my employer this since the pandemic hit, that I did not want to work from home. If they say I have to stay working at home, can I treat this as a constructive dismissal? I have told them I would do it while under stay-at-home orders, but once that is lifted, I want to work back at the office. So that's a great question. It's kind of the reverse of what I've been getting a lot of questions about. So let's be very clear here. If you're able to work in the office and there's no real reason why they keep you out of the office, then yes, you can consider this a constructive dismissal. But here's my concern. Because COVID is such a unique situation, I think the employer may get a bit more leeway in terms of having people work from home. So yes, you can do constructive dismissal. The better way to do it is wait a little bit, because things are getting better with the virus, more people getting vaccinated. And in the coming 2-3 months, things are going to be so good that hopefully that if your employer doesn't take you back to work or tell you to work back in the office, that's going to be a slam dunk constructive dismissal. So I would tell your employer, well, that I'm going to do this for a little while longer while the COVID is still a real issue, but I expect to be back once things are better. And in a couple of months, at that point, you may be able to say enough is enough, constructive dismissal. If the stay-at-home order is lifted in a couple of weeks, it's still not a good situation out there. So the employer can almost justify having you work from home. In a couple of months, that might not be the case. So if you still want to pursue a constructive dismissal, absolutely can help you. Not a problem. You can have entitlements, depending on how long you've been there, as much as 2 years pay, potentially. So reach out to me, again, employmentlawyer.ca. Again, employmentlawyer.ca, the website to reach out to me off social media, off Facebook, off YouTube, so that we can have a private chat about your matter. Please don't hesitate to use that. You see the address on your screen. But for now, ask questions, guys. Love questions. So let's get questions going here. Next question from Xander. Is it difficult to prove wrongful termination? Is it worth pursuing? I was only there for 2.5 years. No, it's not difficult. In fact, one of the most simple things to do is to prove wrongful dismissal. But wrongful dismissal really is a situation of how much severance you're owed. Now, Xander, after 2.5 years, depending on the type of job that you have and your age, you could be owed anywhere from 3 to 6 months, even a bit more than that. But let's say 3 to 6 months. So if you did not receive that, that's a wrongful dismissal, regardless of the reason you were let go. So you tell me, I mean, 6 months pay, is it worth pursuing? Even 3 months pay, I would say it's absolutely worth pursuing. Who wouldn't want 3 or 4 or 5, 6 months pay that they're legally owed? So Xander, let's not talk in hypotheticals. The best way to do it, reach out to me off of social media. Let's have that private chat so I can assess exactly what you're owed and find out more about you, about your job, about your termination of employment, and I'll be able to help you get what you're owed. So I'm going to direct you again, employmentlawyer.ca, again, employmentlawyer.ca, to connect with me and my team off air, email, phone numbers, it's all there. You see it right there on the screen, right there, employmentlawyer.ca. Carrie says, thank you so much for going above and beyond for us all. Yeah, Carrie, thank you. It's a privilege to be able to speak to you and everyone else. So ask questions, guys. From Daniel on YouTube, are employees who already receive paid sick days eligible for the COVID-19 paid sick days? So employees who already receive paid sick days. So bottom line is you cannot get, depending on the province, for in Ontario, we've announced paid sick days. You can't get the Ontario paid sick days and the federal government sick days for the same week. So if you're going to be off for 2 or 3 days this week and you're getting the Ontario sick days, then you cannot qualify for the same week for the government sick days. Now, if you're still sick next week, you've exhausted your Ontario days, then you can get the federal Canada Recovery Sickness benefit that's payable to you. If you've already received the Canada Recovery Sickness benefit in the past, you can still qualify now for the provincial. Again, in Ontario, it's these 3 paid sick days. Just the key to remember is you get the federal benefit and the provincial benefit for the same week. Hopefully that makes sense. Right now, guys, I'm going to continue asking questions, but I want you guys to inundate me with questions. Take advantage. You have plenty of time. This is a live session. I can talk about many things here, and I have a list of things I can talk about between questions, but it's better if you ask questions so that you can have that information, so that you don't have to be stressed out, lose sleep, wonder. Just ask your questions. I'll be able to help you hopefully get some peace of mind at the very least. Let's see. Next question comes from Michelle. Okay. So Michelle says she'll wait a few months about working from home. So yes, Michelle, that's the best advice. See what happens. As soon as things are better in terms of COVID numbers being down, then yeah, you're going to have a really strong constructive dismissal case if you're not back to work. Same thing with you. And by the way, in terms of going back to work, a lot of people are happy now to be working from home. That's fine. And you may have been working from home for a while, but keep in mind that once COVID is better and hopefully in the rear view mirror, your employer can say to you at that point, well, now COVID's not here. Now we want you back to work in the office. So don't assume that just because you've been working during COVID from home, the employer is obligated to allow you to stay home indefinitely. The employer can say, this is a unique COVID type situation. We did that only because of COVID. But now that things are better, we want you back to normal. So that's a possibility. So be aware of that. Of course, any questions, any issues, reach out to me, employmentlawyer.ca. Now, one of the questions I've been getting asked quite a bit, I mean, it's probably been the main question over the past couple of months is, can my employer make me get the COVID vaccine? Can I be told I have to be vaccinated or else? So for most people, the answer to that is no. Your employer cannot make you get vaccinated, cannot let you go if you don't, cannot punish you. Now, I'm not making a comment about whether you should or you should not get vaccinated. I'm only saying your employer cannot make you. Now, for some employees, in rare circumstances where it's a very safety-sensitive type of position, for example, if you're dealing with elders or in a hospital setting, in those limited set of circumstances, your employer may be able to say, you not getting vaccinated is so risky that we can't have you here unless you are vaccinated. But that's going to be the exception. For most people, you can make that decision whether you're going to be vaccinated or not, and your employer has to find a way to continue working with you while still maintaining safety within the workplace. So for most people, no, your employer cannot demand or threaten you with respect to getting a vaccine. It is your decision. And any issues with that, of course, you know what to do. I've said it before. Reach out to me through employmentlawyer.ca. By the way, we do have offices and operations in Ontario, in BC, in Alberta. So anywhere in those 3 provinces, yeah, we got you covered completely. All right, next question from Denise. Can an employer ask you to leave your job and find a new one? What should an employee do? Is this legal? Well, no. The only one that can decide if you're going to leave your job, if you're going to quit or resign, is you. If your employer says you're not going to work here, that's a termination. So let them terminate you. Don't say, well, okay, you've told me to quit, so I'm going to quit. Well, that's giving the employer a gift. You're essentially walking away from your severance. And remember, severance could be as much as 2 years' pay. Why would you ever do that? No. So if your employer says you have to leave your job, you're going to say, thanks, but no thanks. I'm going to continue working here until and unless you let me go. So until then, no, you don't leave, you don't quit, you don't do any of that. You can't be told you have to quit. You can't be told quit or else. You can't be threatened to quit. None of those things can happen. By definition, quitting or resigning is something that an employee does unilaterally and voluntarily. So ignore that. Say, no thanks. I'm going to work until you let me go. That way you get your severance. Okay? That way you can also get EI. If you quit, by the way, you're not going to get EI. Don't do that, please. Any issues dealing with an employer that's threatening you, giving you ultimatums, you get on the phone and you call me, get all that contact information, phone number, employmentlawyer.ca. Just go there on your smartphone, your tablet, employmentlawyer.ca. Get the phone number, call me, email me from there, whatever you need to. But don't just quit if you feel you have no choice. Please don't do that. Next question comes to us from Evelyn. If you are on a temporary layoff due to COVID, what happens after July 3rd? Okay, so in Ontario, the government of Ontario has said that an employer right now can keep someone on what's called an infectious disease emergency leave until July the 3rd. Now, that date may get extended, but even if it does not, what that means is the employer at that point is going to have to decide whether or not to bring the employee back or to end the relationship. Although there's another potential that the employer may put an employee on another layoff that can last another 8 months. But none of that matters. And here's what I mean by that. Because the only relevance of this infectious disease leave is if you choose to accept it. You can choose to treat that layoff. The layoff that may have happened last year, you can choose to treat it now as a termination of your employment. You don't have to wait till July 3rd or any other date. You can say, in putting me on a layoff because of COVID, you've terminated my employment. You now have to pay me severance. Severance, as I said, as much as 2 years' pay. So you don't have to worry about that July 3rd date. Honestly, that July 3rd date is meaningless. Nothing really is going to happen there. It's not going to give you any new rights over and above what you have right now. So if you want your severance, if you want to know enough is enough, you can get your severance right now. Otherwise, you could be waiting potentially, forget about July, you could be waiting until March 2022. That's 8 months after July, okay? So hopefully that answers the questions. If not, Evelyn, ask a follow-up question. Happy to answer it. Continue asking questions. Guys, it's some of the greatest questions today, so I love that. Ask your question as well. You have plenty of time. I'm here for a while longer. Next question comes to us from Gita. Can an employer change the nature of the job of an employee who refused to vaccinate? This is to avoid close contact with other employees. Would this be considered a constructive dismissal? It's a great question, Gita. Actually, it's a fabulous question. The answer is an employer can do that, but only if that's the only reasonable way to keep people safe in the workplace. So if they could have the employee continue working without changing the job, then they have to do that. But if the only way they can really ensure safety is by changing the job because the employee didn't get vaccinated, that's okay. Because an employer has to maintain safety of not just the employee, but all employees. So if the employer can show that, well, if I don't change the job, it's unsafe, then they could do it. But the employer has to prove that. They can't just unilaterally say, well, we're going to decide unilaterally that anyone that doesn't get vaccinated is going to do this job. There has to be a reason. It has to be tied to safety, and it has to be the only way to ensure safety. If it's not the only way, it could potentially be a human rights violation, and certainly it could be a constructive dismissal. So happy to talk to you in private. If you want to talk to me about this specific situation, you can reach me through employmentlawyer.ca. Next question from Ria. I have been working for 4 years in the same company. They downgraded my title last year. In October, I signed a new position job description. However, things are getting worse. Can I still file a claim for constructive dismissal? Unfortunately, no, you cannot. Because it's been at least 6 months or so, or maybe more now, could be 8 months or so since you signed this change. And because you actually did sign, you've accepted the job. Now, if they've changed that job since, maybe there's an opportunity. But if it's now you realize, wait a second, that was a mistake back then, I shouldn't have agreed to it. Unfortunately, Ria, it's too late to say constructive dismissal. That's why it's so important, so important. If your job changes, whether it's your job responsibilities, or your hours or your compensation or your work location, if any of those things change, you have to consider this concept of constructive dismissal. Do you want to accept it and continue working and then may realize that you're stuck? Or do you want to say enough is enough, I want my severance, I'm going to not continue working, the employer has breached the terms of employment. If you are facing a change, you have a small window, usually a few weeks, to do something about it. So if your job, your compensation, your hours, your shift, any of that changes, you want to reach out to me now. Not next week, not next month, now. employmentlawyer.ca, you see that right here, the way to reach out to me, to find out about your rights, and also to get my contact information so that we can have a private discussion. Please don't hesitate to use it. Next question. We're getting lots of questions today, guys. This is terrific. From Barbara, next question on Facebook. When an employee asks for transfer because it's not working out, and if we transfer an employee to a temporary job for 2 months after she resigns, do we pay her severance based on the job she held first, on the temporary replacement job? So So the best way to look at that is this way. The severance that you have to pay covers a period of time. So let's say you owe someone 6 months severance. If during that 6 months she would have continued working in the temporary job, had she stayed, then you have to pay severance based on that. If in that 6 months she would have had to go back to her old job, then it's that old job. So really it's a question of what would have happened had she stayed. If we're not sure, then we're going to use the position that the employee had at the time of termination. Remember, you say something about resign. Severance is not paid if an employee resigns. If it's a true resignation, severance is paid if the employee is let go by the employer. So the first thing to determine, of course, is the amount of severance. And for Barbara and for everyone else, if you want to find out today, immediately, now, how much severance is owed, easy. Just go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. It's a tool that we have. You see that on the screen right here that allows you to calculate your severance. We have a severance calculator there. You can find out in seconds, anonymous, free, easy, with 3 questions, how much severance you're owed, or if you're an employer, how much severance you owe someone. So just go to pocketemploymentlawyer.ca. If you lost your job, if you're worried about losing your job, if you're curious, or if you want to know what your friend or family member is owed, pocketemploymentlawyer.ca. But for now, right now, you still got some time. Let's answer some questions. Ask yours. From Fabiola on Facebook. My employer terminated me without cause. It was supposed, it happened in Alberta. The company told me they didn't pay severance. However, I will have a right of VI. I was assistant manager at a big retail jewelry for 4 years. Is it right? It's nonsense. It's not even close, Fabiola, to being right. They probably owe you about 6 months' pay. That's a wrongful dismissal. That's not even close. You have to give me a call, okay? employmentlawyer.ca to get my number. That's a wrongful dismissal. They don't get to decide not to pay severance. The law decides that. Potentially easily 6 months' pay is what you're owed. So just go to employmentlawyer.ca, grab my phone number or my email address, and reach out to me today. Thank you, Fabiola. Carrie says, I was told about a year ago that we could do nothing until after June of this year. I'm not sure exactly what you're referring to, Carrie. If you're referring to the infectious disease leave, you can do that now. June doesn't matter. You could have done it even a year ago. So that's not true. You want to reach out to me and I'll help you. Teresa asks, my husband has been temporarily laid off since March of 2020. He barely hears from his employer, and so he's reached out to them. He still hasn't heard back. What can he do? He wants to know where he stands. So he only has 2 options, Teresa. He can continue waiting and hope for the best and keep fingers crossed that things work out. That's option number 1. Option number 2 is he can choose to treat this layoff as a termination. He can make that decision. He doesn't have to wait to hear from the company. He can make the decision to say, that's a termination, you're owed severance, or he's owed severance. If he wants his severance, he's not going to just be able to send them an email and say, pay severance. He'll need my help. I'll do that. I do that for a living. My team does that for a living. So those are his options. Wait and hope for the best. He could be waiting for a long, long time. or make the decision himself to say, I want my severance and I want it now. If he wants his severance, have him contact me, employmentlawyer.ca. Thanks. Hopefully that answers it, Teresa. Gita has a follow-up question. An employee has accepted another role with the same company. In this role, he is getting less leaves. He is asking to keep his old leaves, but the company can't do this. Can the employee still ask for the old leaves eligibility? Well, it's not really. If he accepted another role with different leaves, there's not much that can be done about that. It's always important to understand what you're agreeing to before you agree to it, rather than say, okay, I'm doing this job, and then say, oh, now I want more leave, because he may have been able to negotiate at the beginning, but there's no real way to say, you have to pay me or give me more leaves. There's no legal obligation on the employer to do that. So thank you, Gita. Great questions today, guys. You guys are really keeping me on my toes. That's awesome. Keep it coming. We have some time still. Next question comes to us from Tamara. My job requires me to occasionally go into people's homes. I'm very concerned because of the risk of contracting COVID with my compromised immune system. Can I refuse to enter homes after the lockdown ends and COVID is still an issue? So you can refuse only if you have a doctor's note. Now, your employer or has to ensure that the homes you go to are taking the appropriate measures in terms of masks and social distancing. If that's not happening, if people are not wearing masks and they're shoulder to shoulder with you, you can absolutely refuse. But if they're social distancing and mask wearing, you do have to go unless you have a doctor's note saying you can't do that. If you have a doctor's note saying can't do that for medical reasons, they don't even have to say what the medical reason is. Just that there's a medical reason, then your employer can't make you. They have to either accommodate you if it's possible. If it's not possible to accommodate you, they have to allow you to be off work without penalty. So those are the options, but you need that doctor's note, of course. Easy, speak to your doctor. If your doctor agrees, a 2-line doctor's note is all you're going to need here. So hopefully that helps, Tamara. Any questions or issues, or if your employer does anything to you, you know what to do. So do you, everyone else. Reach out to me through employmentlawyer.ca. You see that right there? I've learned how to point to the right direction. Okay, next question from In It to Win It. You've been with us before. I love the name. Is litigation in cases delayed during these times if it's been a year now? Really only in small claims it's been somewhat delayed, but even that's starting to move. In other non-small claims, no, we can still move things along. We can still do what we need to do. You just need a lawyer that knows how to use the system. So that's the answer there. Small claims are a bit different. Oh, God, looks like I've caught up on questions. So if you do have any last questions, I'm here for another couple of minutes. Don't hesitate. Ask your question as well. I'm still here. I'm still live. I've mentioned before pocketemploymentlawyer.ca, and I've told you that at pocketemploymentlawyer.ca, we have our severance calculator tool. You see that right here. So the severance calculator, as I said, it allows you to find out how much severance you're owed, how much compensation you're legally owed if you lost your job, if you've been constructively dismissed, etc. But it does more than that. We have other tools there. For example, you can find out if you've been constructively dismissed, if your matter is a constructive dismissal. We have that tool there. You can find out if the company has just cause to let you go. Many people are confused. I did something wrong, but is it just cause or not? Well, you can find out at pocketemploymentlawyer.ca. If you are wondering if you're truly an employee or an independent contractor, you can find that out there as well. Many people, most people, I would say, are misclassified. They believe that they're independent contractors, but the law considers them to be employees. And that could be relevant because you may be owed vacation pay and overtime and severance if you lost your job, if you're an independent contractor that's been misclassified. So if you want to know if you're an independent contractor or an employee, go to pocketemploymentlawyer.ca. If you want to find out if your matter should be considered a human rights violation, if your matter is considered harassment, if you've been improperly cut off by your insurance company, disability insurance company, you can find out all that and get an assessment of your situation for free in seconds at pocketemploymentlawyer.ca. It's like having me and my whole team with you on your phone in your pocket at all time. That's why we call it pocketemploymentlawyer.ca. So any employment law issue, first place you go to, you grab your phone, you type in pocketemploymentlawyer.ca, voila, everything you need is right there. I think for us this week, this will be it. It was a real pleasure and a privilege to be here with you. Thank you very much for your time, for your questions. If you didn't get to ask your questions, or if you have follow-up questions, or if I've told you during this session, you got to reach out to me directly. Just go to employmentlawyer.ca. You can have my phone number. It's right there, my email address. I can connect you with any one of my colleagues as well. So go to employmentlawyer.ca. Don't wait until we're here next week to ask your questions. Do not do that, okay? Ask now. Go to employmentlawyer.ca. But I will be back next week, same time, same place, to take on more questions. Thank you very much, everyone. Have yourself a good rest of the day and the rest of the week, and we'll talk to you soon.